SJC-13547, Commonwealth versus Richard Dilworth, Jr.
Okay, Attorney Fitzgerald, whenever you're ready.
Thank you, Your Honor. Good morning, and may it please the court, Caitlin Fitzgerald for the Commonwealth. With me is ADA Elizabeth Martino. There's a lot of issues to talk about today, but at the heart of this appeal is that the trial court misinterpreted and then misapplied the discovery rules as they apply to equal protection discovery in this case.
Can I ask you about intrusion, what that means in Van Rader? You posit that unlike a Fourth Amendment Article 14 intrusion, this isn't actionable because there wasn't enough police conduct, essentially. Would it be an equal protection violation if a police officer is stationed at the side of the road and there's affirmative evidence that they write down and run license plates only for black drivers?
Yes. The question is not whether or not...
The motorist is unaware of what happens. So if that's a violation of equal protection, why is solely focusing on, as they allege, people of color in their social media?
So the question is not whether or not equal protection applies. Equal protection always protects people from unequal enforcement of the law. The question is what the remedy is. And this court...
We've said the remedy is suppression.
So there is no case that I've been able to find that suppresses evidence without a constitutional intrusion. So this court in...
What's the remedy for the constitutional violation?
So as it stands right now, it would be a 1983 claim. It would be a civil suit.
Okay, I thought we crossed that road in Long, and actually, in the case that's preceded Long,
So
Justice Cordy said, we're going to call this an exclusionary rule violation, right?
yes, so I believe that the first...
You want us to backtrack from that?
No, Your Honor. So the first case that allowed for suppression in the Commonwealth, my understanding is Laura.
Right.
That was a constitutional seizure. Long addresses constitutional seizure. The Commonwealth is just asking the court if the court is going to extend suppression jurisprudence in this context.
I thought, so Laura says in our jurisprudence,
Yes.
a violation of equal protection, the remedy is exclusionary rule. Long says that, Van Rader says that, and you want us to change it.
So all three of those cases involve a constitutional seizure, Your Honor. Van Rader does discuss consensual encounters on the street and its reasoning, but that's not what Van Rader was. So the Commonwealth is just asking this court that if suppression jurisprudence is going to be extended to pre-seizure activity, that this court consider in doing so, now that that issue has squarely been raised before the court in this case, would ask the court to consider creating a pragmatic discovery standard that would allow for the variety of allegations that could arise in the criminal courts. So, Your Honor...
What would that standard look like? Part of the problem I have here is that the Commonwealth really did nothing to help the judge down below, that decided ultimately not to comply with the discovery order. Don't we first have to look at the dismissal and determine whether there was an abuse of discretion there, and then determine whether or not there might be some, as you call it, pragmatic discovery approach? Because here, I don't really see how we get to that question.
So I think I see that Your Honor's question is really three parts. First, the Commonwealth would propose that the Betances-Bernardo B standard that's already in place for pre-seizure activity add a step that allows for the court to consider rebuttal evidence from the Commonwealth at the discovery stage. And I can, in a moment, if the court wants, I can kind of use this case as an example of how that would have worked. The court also mentioned that the Commonwealth did nothing to...
So that would be before you produce the discovery that the court has ordered?
For pre-seizure cases, yes. So I can give an example in this case, Your Honor. In this case, the defendant submitted an affidavit saying, I conducted an informal survey of my fellow public defenders. I received 20 responses. That the inquiry was, if you have a client who is charged with a crime following a Snapchat investigation, could you let me know the race of your client? 17 of those clients were Black and 3 were Hispanic from the 20 responses that counsel got. If the court were to find that that met the Betances-Bernardo B standard, which the Commonwealth would submit, it does not, but if it were, the burden would shift then to the Commonwealth at the discovery phase to offer race-neutral
Did you
reasons.
make that offer here?
We did, and we did that at each stage. So at the first discovery motion, we did object, and we offered, I believe we offered an in-camera hearing that was rejected by the judge. We then did a motion to reconsider, was denied. We tried to take a 211-3, that was denied. We appealed the denial of the 211-3, and that was denied. We turned over the discovery. We then had a second discovery order. We objected again.
But the discovery you turned over was not of the sort you just proposed our allowing. It was the discovery that the judge ordered.
Correct, but I guess
Not countervailing information.
the countervailing information we offered at the first discovery motion was an in-camera hearing to offer a race-neutral reason.
Why would we change the ordinary relevance standard for discovery because there is an equal protection argument at issue? It seems to me contrary to all constitutional law to make a defendant who's asserting an equal protection argument jump through a loophole that ordinary relevance doesn't require.
So again, the Commonwealth is only asking that this be done in pre-seizure cases. And typically
But why? Why would we treat pre-seizure cases that implicate equal protection any different than ordinary discovery, which is usually just the relevancy?
Because of all of the different scenarios that could be implicated. If I may give an example, the court had mentioned previously a SJC check. So if there's a court order for SJC records, that's understandable. That's something the Commonwealth can produce. But what if a defendant raises a claim and says, I was arrested in area B2, Roxbury, and I'm aware through publicly available sources that the Boston Police Department has more officers stationed in Roxbury as opposed to West Roxbury, and Roxbury has a higher Black population than West Roxbury. Therefore, I've met my burden of relevance that I may have an equal protection claim, and I want 1 year worth of reports from each of those 2 districts, without allowing the court to consider rebuttal evidence from the Commonwealth, which might take it might be evidence that the Boston Police Department expands its resources based on 911 calls or a reported crime or something like that.
But Van Rader says investigations, not deployment of resources.
Correct, Your Honor. But I believe that what we're doing here is really, I think that if there's more resources, there's more investigations going on. This is why the Commonwealth is asking for this court to now that the pre-seizure issue is not squarely placed before this court in Van Rader, and the Commonwealth is asking this court to, now that it has been placed squarely before you, consider all of the different motions that could be filed
I guess
here.
back to my question, why would we have this heightened burden on a defendant to seek relevant discovery in connection with a constitutional alleged violation? It seems to me backward to actually heighten the discovery.
So
You were going through your scenario about West Roxbury versus B2. What I don't understand why we would withhold discovery. What is the consequence to the Commonwealth?
So the consequence in the example I gave there, if the court is not allowed to consider essentially anything that the defendant is raising in context, it's a burden to the Commonwealth, it's a burden to the court.
What's
Now,
the burden?
The burden is turning over thousands of police reports that will surely need to be redacted. So it's a time burden. And it's a burden on the court to be hearing essentially motions that at the end of the day will have no merit. So what the Commonwealth is proposing
You're
is
proposing to prejudge the merits of the motion before the defendant is allowed to have discovery on equal protection grounds.
For pre-seizure cases, the Commonwealth is asking for the court to be able to consider the context of the defendant's affidavit, which is not what currently is happening.
Incorporated in Article 14, Fourth Amendment concept into equal protection discovery.
So
The
don't-
answer is
I don't-
yes.
I know, you
Well,
can't say
so-
no.
So yes, so seizure again is relevant here for a couple of reasons. One is that, again, we're talking about suppression. There is no case law currently, and I'm not saying that there won't be, but there is no case law currently allowing for suppression as the remedy pre-seizure. I think the other thing that is implicated pre-seizure is, and this court has always acknowledged in its equal protection cases, that there is a consideration for separation of powers here. In Laura, the court acknowledged that the day-to-day enforcement of equal protection of the laws is primarily in the hands of the executive branch. And the court in Robinson Van Radar, again, discusses this, and that decision says, the charging decisions of the police and the prosecutor are guarded more by separation of powers. The decisions of police in stopping, searching, things of that nature, those are always subject to judicial scrutiny. So there's less of a separation of powers issue there.
There is a proffer here at the first stage by the defense that, has some weight to it. All 20 are people of color, right? So there in the first stage, there is an evaluation of whether there's some weight to this, right? Which is what you want at the second stage, but we've dismissed some of these at the first stage, right?
So I think that's a difficult question to answer, because I don't think that there was any.
But isn't that the case? The case involves, the defense has made a proffer that's concerning, that all 20 of these, now it may be distinguishable down the road, but doesn't that get them into the discovery phase?
No, Your Honor, and here is why. Again, I believe that the standard is still Bernardo B., which is a relevant and material standard.
Isn't the standard Cuffey?
So I would say that, one, Cuffey cites to Bernardo B., but two, Cuffey, as you know, came out with Robinson Van Radar, and the Commonwealth would say that Robinson Van Radar and Long are exceptions to the general rule.
But Cuffey's a relevance case.
So Cuffey
As Justice Wangman points out, Cuffey is a relevance inquiry.
So is Bernardo B., Your Honor. So it quotes exactly Bernardo B., but in order to be relevant in the equal protection context, there still has to be some evidence that of each of the three Franklin tests.
What case holds that?
So there's no case that explicitly says.
Right, because that's the test for the merits of the equal protection argument, not whether or not you get discovery in order to make the argument.
If that's the case, Your Honor.
Well,
then
it is. So tell me why we should reverse all of our jurisprudence to make relevance not the standard for getting discovery in order to marshal an equal protection argument.
So I don't think that the court needs to reverse the fact that relevance is the standard. It's the Commonwealth's position that if there's not what equal protection is at its heart is whether or not similarly situated people are being treated differently.
Right, and so we have a defendant who comes forward with 20 out of 20 people being targeted by Snapchat being people of color. Why isn't that enough to get the discovery?
So the defendant is.
And what are the odds?
So I think, again, this could have limited this could have given some context. If counsel had attempted to hit all three prongs, it would have been very easy for counsel to reply all to his initial email and say, if you have a defendant who is charged with a firearm by the Boston Police Department, please let me know their race. Not including Snapchat, just people who have been arrested with illegal firearms in the city of Boston. Comparing the racial makeup of those two groups, if they are disparate, it would raise an equal protection claim. But just saying, I mean, that would be the same as counsel.
So you lost that motion, right? And you agreed to produce discovery, and then you lost the second motion, and then you lost the third motion, and then you told the judge, well, we're not going to produce the documents anyway. And why was it an abuse of discretion in light of the Commonwealth's failure to provide an alternative remedy at all to dismiss the indictments?
It was an abuse of discretion because it was an abuse of discretion to order the discovery in the first place.
Okay, so you lost those three, and so now you're complaining because the indictment was dismissed, having lost 3 times at bat.
So the last time that the equal protection was really analyzed on its merits was in January of 2019 when Judge Ullman issued the order. And after that, the Commonwealth had...
And what was the result of that merits analysis?
He found that...
No, what was your ultimate final decision on that merits analysis?
Decision of the court?
Yeah.
The trial court ordered it.
Yep. You
We
appealed to the single justice.
Correct.
You lost. You appealed to this panel, and you lost.
Correct.
Okay.
And-
So on the merits, you lost. The discovery, and now you're not producing the discovery to the defendant, having battled it all the way to the panel of the Supreme Judicial Court. And I'm sorry?
The Supreme Judicial Court nor the single justice addressed the merits. And in footnote 5 of the Dilworth decision by this court, it specifically says that the merits were not reached. It was just that the court was not abusing its discretion and not using extraordinary powers of appeal at that point. So the Judge Ullman issued a decision ruling on the merits. In that, he said, it is not a case in which the defendant has shown a person of different race similarly situated to him was treated more favorably than he was treated. It's the Commonwealth's position that is what an equal protection claim is, and that's the only ruling we have. Judge Krupp in the subsequent 2 orders specifically stated he was not going to readdress the merits because Judge Ullman had already reached them. So the Commonwealth did everything that we could to try to get these merits raised again. The only way that we could do that ultimately was to do what we did and not comply with the discovery order. So it's
Counsel, excuse me. My reading of the record, and can you please point me to something in the record if I'm wrong? My reading of the record was that Judge Krupp repeatedly said he was not going to revisit Judge Ullman's rejection of the Commonwealth's argument that a seizure was required, and rather than anything else. Is that incorrect?
My reading of the decision was that he was not readdressing the merits of the issue, but I don't have that in front of me at the moment, so I apologize if that's
Thank you.
not correct. I see that I'm over my time.
Okay,
So if there's no other questions, I will rest on my brief. Thank you.
thank you very much. Okay, Attorney Cohen.
Good morning, and may it please the court. Josh Riesler-Cohn on behalf of Richard Dilworth. Mr. Dilworth's discovery motion easily meets the material and relevant threshold where there is a reasonable basis to infer that racial profiling may have been the reason.
Why do you need the Bitmojis?
Certainly. So the prior discovery orders that were produced after the appellate procedures that this court has just reviewed, those prior discovery orders essentially produced evidence that was going to be relevant to a statistical analysis. So the number of people that were arrested and charged in this investigatory scheme during the relevant time period. There was also a disclosure of the total number of people that were targeted for surveillance with this investigatory scheme during the time period that was relevant. But the Bitmoji and the username is different than statistical evidence that would raise a reasonable inference. And our position is that the Bitmoji and username is actually going to be direct evidence of the intent of the officers who established this investigatory scheme, not inferential evidence.
Explain that?
Certainly. When creating the Bitmojis and when creating the usernames, the officers are making discretionary choices about things like skin color, skin tone, hair color, hairstyle, and actually within the online application where you are creating the cartoon character, there's other phenotypes that you select for, including things like the width of a nose or the fullness of a face. There's a variety of phenotypes that you select, and all of those things potentially could reflect a decision by the officers to create a Bitmoji or a username that reflects the population that they're choosing to target with this investigatory scheme. As the, I believe.
What about usernames? I mean, that seems, Bitmojis seem to me perhaps more understandable on this front, but the usernames seem to me, can you give me an example of a username that would reflect in some kind of reliable way a discriminatory intent?
So the username at issue that the officers connected to Mr. Dilworth was YoungRick44 or something like that. But I think because like the undercover accounts set up, or the false accounts set up by the Boston Police Department, because people generally aren't using their real names, people are using other kinds of social signifiers. The amicus brief authored by the ACLU and the Innocence Project talks about the way that online social networks have some overlap with in-person social networks where there is some sort of self-segregation, and there are sort of safe havens where people come together with shared experience and shared backgrounds. And our anticipation is that, like the Bitmojis, the discretionary choices that the officers made about the names that they're selecting for these accounts is going to reflect the communities that they're trying to infiltrate with this surveillance. I don't have the names of the accounts being monitored were not disclosed in the discovery, nor were the names of the accounts used by the Boston Police.
This is undercover police work, right?
I think that's the closest analogy.
So, under your analysis, this would only be okay if the person has a Bitmoji where he looks like Joe Friday and he has a police cap on and he says Joe Friday?
So our position is that
That's not real good undercover work, is it?
No, I totally understand Your Honor's point.
And that's what we discussed in Carrasquillo as well.
Well, in Carrasquillo, I think the main issue the court was addressing was whether there was an expectation of privacy for the purpose of the Fourth Amendment.
We litigated Carrasquillo, expectation of privacy, which bleeds into their argument a little bit. But we litigated Carrasquillo, and we were able to litigate it. Judge Locke below in Carrasquillo did not disclose the name of the username of the undercover police officer, and we said that was okay, as long as you didn't use the name of one of the known associates of the defendant, correct? To show that the randomized friending of the person. And you could litigate your claim without knowing who the person was.
Without knowing who the actual person was?
Without knowing the cop's username.
So our position is that these, and I think based on the very substantial showing that we've made so far, not only with the number of people who were arrested in this scheme, but also with the number of people who were targeted. Of the 2,700 people that we are aware of targeted in this investigatory scheme, I believe it was about 87% of them were people of color, of the people whose race was known.
But so you have that information. What I don't understand, and to Justice Gaziano's point, is how the usernames or the Bitmojis helps your analysis. I don't really understand. We need to draw the line between the dots. I don't get it.
Certainly. I think both the Bitmojis and the usernames reflect intentional discretionary choices at the very initial stages of this investigative scheme.
Right, to fit into the community. How is that, so that you will be allowed to follow the Snapchat account? How is that an equal protection, how does that help your equal protection argument?
So if the choices that the officers made were to create Bitmojis that were black, mostly black, and almost exclusively people of color.
Then what?
And used usernames of a similar kind. I think
That
that
usernames that reflect that they're black?
potentially.
What, okay, and so draw the line there. What does that mean?
I think those discretionary choices supplement the statistical evidence that we have, right? Under the framework of Long and Van Radar, a defendant can make a showing with statistical evidence or with totality of the circumstances.
Either way, you've proven that they've targeted primarily African-American housing development, and they're looking for people who are involved in gang violence. Given that, then the burden becomes on the Commonwealth to say why they did that, to give a race-neutral reason under all the case law. So whether or not the Bitmoji looks Norwegian or African-American, what difference does it make?
Well, if the Bitmoji reflects what we think it's going to reflect, then that becomes...
That's called undercover work.
Well, it becomes a piece of evidence that the Commonwealth has to grapple with in the totality of the circumstances at the rebuttal stage.
So why isn't the remedy just an adverse inference or a accepted fact that the Bitmoji and the username were designed to blend into the targeted community?
I've thought about that a lot. I think it's a good question. Our position is that because there are so many choices that were made in the creation, specifically in the creation of the Bitmojis, there's at least 1,000 possible combinations of variables that could be created. I think that number is right, but there's many facial features and characteristics that can be selected for, and the username options are unlimited.
But how, counsel, how is that going to be litigated? Because infused in that comment is a racism that needs to be addressed as well. Because you're saying that if we look at all of these choices that are made, so if it's a broad-nosed, black-skinned person, there were narrow-nosed, black-skinned people. Absolutely. You're saying who's going to say, when we say now the username, who's going to determine whether that's a black username or not? And in this case, it wasn't the black username. So how are we going to, back to Attorney Fitzgerald's point, the courts now are going to sit back in the totality of the circumstances. We're going to have judges making a determination as to whether or not this looks like a black person's emoji or a black person's username? Is that what we're going to be doing?
So I think that, Your Honor, your point is very well taken. And I think our position is that the issue in an equal protection claim, unlike a search and seizure, is the discretionary choices the officers made about who they're going to target. And we anticipate that this is going to be visual evidence of who the officers are intending to target. If at the merit stage, the Commonwealth and the officers present a race-neutral reason, then that's exactly what's appropriate to do at the merit stage of a hearing.
Is it evidence of who they intend to target, or is it evidence of who they intend to appear like?
I think that's a question that has to get resolved at the merit stage.
But, so look at it this way. So if you have a CI, right, and the evidence that you get and you do the groundwork and you say, listen, they're trying to intercept this ring of drug dealers who happen to be of a certain ethnicity, and they bring in CIs, and our investigation reveals that these CIs go and they just look at people of color, and you bring an equal protection claim because of that. Does it matter what the CIs look like?
I think what the CIs look like...
CIs are trying to blend into the community to buy drugs from the target drug deals, right?
In that context...
Do CIs have to have crew cuts?
In that context, the CI may reflect, as Your Honor is saying, the investigatory discretionary choices that the officers are making. And whether or not that implicates equal protection, I think can only be litigated when a defendant has access to discovery and is able to proceed to the merit stage.
All right, so that's an equal protection claim, that they're using CIs that blend into the neighborhood.
The choice to use that CI may or may not be the equal protection claim itself, but it may be evidence of the intent, and the evidence of the intent is relevant to the
intent is to get the people to sell them drugs. The intent on the Snapchat is to get access to get the pictures of them flashing guns, right? That's the intent.
Well, I think
to have trust, essentially.
I think this is exactly the challenge that Mr. Dilworth has, which of not getting all of the discovery that he's seeking in order to raise the claim at the merits. I think all of these questions are important, viable questions that we have to address at the merit stage of the proceeding. But in order to have an opportunity to do that, in order to have an opportunity to present the evidence.
I thought short of the Bitmoji and usernames, the Commonwealth did provide you with all the other discovery. Is that true?
Most of the other discovery.
But really, it's this extra piece of the Bitmoji and the usernames that this case is ostensibly about.
I believe so, yes.
Okay.
Can you address the dismissal with prejudice? I mean, we tend not to, that's the last resort, right? So can you tell us why that's correct?
Yeah. So I believe that in Judge Ullman's dismissal order, he did note that there was a note in one of the last sentences that if the Commonwealth's position or this court changed their position, that the issue could be revisited. However, where Mr. Dilworth was denied access to court-ordered discovery and where the Commonwealth chose to willfully and intentionally refuse to comply with a court order, our position is that fits squarely within the framework of Washington W, where dismissal would be appropriate. Obviously, of course, suppression is a remedy for police misconduct, and part of the reason for that is because the suppression is designed to advise the police about what sorts of behavior they can't be doing anymore. And I think in this context where it was the Commonwealth's decision to refuse to provide discovery, even though this would be litigated at a motion to suppress, at this point of the proceedings, dismissal has the deterrent effect on the Commonwealth from refusing to comply with court orders.
I just want to give you a chance to explain again, and because I'm having trouble understanding why it's so important to have this particular information. As Justice Gaziano said, we already know they're trying to infiltrate, right? So let's assume that they're trying to look like the people they're trying to connect with. You already know that. You already know that. So how does this information help?
Well, so this information is relevant to I think it's going to be relevant at a merit stage to the testimony of the police officers and to the ability to cross-examine the police officers about the choices that they made at the outset of this investigatory stage.
Let's
assume
that instead of having the case dismissed, the answer is we're going to assume that they did what you're saying they did. Okay.
So I think even with that inference, that precludes Mr. Dilworth from being able to cross-examine the officers about the specific decisions the specific choices that they made and how they set up this investigatory scheme. A generalized inference doesn't take into account the actual choices that they made in creating those Bitmojis, and which is analogous
you have the Bitmojis in your case, and you can easily get them in the other 20 cases the defense counsel's already produced for you. So you've got, right? You can ask those defense counsel, was the emoji a person of color, or was it a person of Cambodian descent, whatever, or a white person? You can ask them that, right? So you've got a lot on this issue already.
So in terms of the Bitmojis that were used by the Youth Violence Strike Force to monitor people, we don't have any of those. I'm not aware of the account that was used to follow Mr. Dilworth, and I'm not aware of the account, and I don't think any of the other defense lawyers
Mr.
are aware.
Dilworth is not aware of the emoji that was used?
These are false accounts that are operated under subterfuge.
He has so many followers that you can't
and
figure out
there's
what it
no,
is. Right.
As far as we know, we don't have any idea what the account is that was used to follow Mr. Dilworth, and as far as I'm aware, no other defense lawyer or defendant is aware of that either. So we don't actually have that initial descriptor.
So the prejudice to your client that merits dismissal of the indictments is?
So our position is that the discretionary choices that the officers make in setting up this investigatory scheme, like the selections about race and the selections about hair color and hairstyle, those go to the core claim that Mr. Dilworth has, that he was targeted because of his race. He can make an inferential showing with statistics.
Okay,
but
hold on a minute, counsel. He was targeted because he can't stop flashing and posting videos of guns. Okay, the affidavit that was submitted in response, the Youth Violence Strike Force, commonly known as the gang unit, they're targeting gang people. Okay, so the idea that this is just kind of randomized infiltration of black communities, there's a specific targeted community that they're looking to, and those are folks that are gang related that possess unlawful, illegal weapons repeatedly, right? Because we have this case where Mr. Dilworth was arrested after whatever was witnessed online, and no sooner does he hit the street, he does it again. So it's not this generalized kind of targeting that I see here. It's a specific targeting.
I absolutely understand Your Honor's question, and I think what part of my response is that we don't know why the police decided to target Mr. Dilworth. He was targeted months before the observations was made. The reason that he specifically was targeted has never been disclosed in this discovery litigation, but certainly he was targeted long before the police made the observations that they made in this case. We also know that of the 2,700 people that are being monitored in this investigatory scheme, at that time, back in 2017, 2018, officers didn't know the names of about 65% of them. And I think that really raises a question about whether this is specific targeted investigation connected to criminal activity, or if this was more of a social dragnet that actually implicates the Equal Protection Clause. And that's the discovery that we're seeking we're seeking discovery in order to litigate that question, in order to put that question before a judge, to put the officers through the crucible of cross-examination, to understand the credibility of the race-neutral reasons that they would present, and to actually have an opportunity to present a claim. This court has established robust and clear equal protection jurisprudence in the Commonwealth, and one of the cornerstones of that jurisprudence is the ability of defendants to investigate the investigatory scheme that targets them. Without that discovery, Mr. Dilworth
The inference
doesn't
you
have
seek to draw is that the police are racist because they pick black Bitmojis.
Your Honor, where this court, that's not what we're saying. I think where this court has in long described that evidence may be based both on implicit and explicit bias, and the officers are making discretionary choices, and all of the discovery that we've gotten so far documents a very significant disparate impact. I think it's appropriate for Mr. Dilworth to seek evidence that he believes will be direct evidence that he can present at a hearing.
But either way, just like if there's evidence that the police are, based upon their mobile data terminal information, are just typing in, a 24-hour period, one cop is on the side of the road, the first analogy, is just typing in names of black people, motorists, right? You have the data, which is irrefutable, and you can now use that to establish the burden, to put the burden on the Commonwealth, right? Here, if you have information about targeting of social media, the burden is then going to shift to the Commonwealth, correct?
That's correct, but I do think it's important for a defendant like Mr. Dilworth to be able to raise both a statistical claim and a claim in the totality of the circumstances, and to raise evidence that would provide an inference and to raise evidence that potentially would be direct evidence, and that's what he's seeking to do.
But you're going to get direct evidence if they have to say, we set up these accounts, and all the people that we set up accounts on happen to be people of color. And the big question is the why, which is the issue in equal protection.
Right, and I think the choices that the officers made is one part of the answer about why.